Hello, everyone. Dr. Ames here. This time I'd like to talk to you about the ADEA, which is the Age Discrimination and Employment Act, which was passed in 1967. Um, Prior to the time of this legislation coming along, there were a lot of employers who would not hire anybody 40 years of age or older. And in fact, before this time, most organizations had mandatory retirement policies at age 65. So generally, we would have to say that this act has had very positive results for older workers. Today, we know that certainly older workers stay in the workforce until the very end, as long as they feel able to do a job and feel competent. They want that full-time job in general, and they want to be part of the workforce. Um, and there was no doubt about the intent of this act. It was to stop the blatant discrimination against workers 40 years of age and older. And this is really about half the workforce. It has only increased the percentage of workers who are 40 years of age and older over time. Um, the act was meant to promote job opportunities, regardless of age, for all qualified older applicants, uh, to remove the forced retirement mandate, and protect all workers from being forcibly retired due to age. Um, but there were a few caveats with it, a few slight restrictions depending. It only covers employers that have 20 or more employees. Uh, it covers employers that have labor organizations. It covers employment agencies and all the people that they hire on a contractual basis. And it covers all government employees. The original act said that workers could not be forcibly retired before 65. Um, Later, this was expanded to 70 years of age, which was in 1987. The act was updated and it removed, at that time, all age restrictions for mandatory retirement. Um, the act was again expanded in 2005 to allow older workers to actually sue their employers if they felt that they had been discriminated against on the basis of age. So age bias became a viably legal remedy to protect an older worker. But employees had a hard time winning the great majority of these cases. In fact, they didn't win most. It was very difficult for an employee to show that there was adverse effect, not intentional discrimination, and so forth. Um, and so these things happen, and that's why we have the EEOC, the Equal Employment Opportunities Commission, which is the body that has the legal responsibility to investigate claims and further them to court if they, whatever their findings depend on. Now, the one exception to being able to say, no, you're too old for this job, to discriminate in effect against an older worker, is if the job requirements had a BFOQ, which means a bona fide occupational qualification. In other words, age has nothing to do with the restriction here. It's the job needs itself that demand that you only hire a certain type of person. Well, the government has decided that the only part of society that can really prove that they have a really strong BFOQ that qualifies would be a religious organization, and that is it. Um, Regular organizations simply cannot find grounds to say this is a logical reason why we have to discriminate against you. What the employer would want versus what would be legal in infringing on someone's rights comes into play here. So the BFOQ, it exists, but you have to remember that it really only applies in the case of religious entities. Now, when it comes to employment practices, what the Act really encourages is that consistency is the name of the game. That if you act consistently as an employer and you follow the rules and you have a plan for when things go off the rails a little bit and you follow the plan, then charges of bias and discrimination generally are not going to work against you. And employers need to protect themselves. So you need to have viable plans to report abuse and so forth and to follow through in good faith in your own investigations. So your policies on these sorts of things that deal with age or termination and things like that, your practices have to be extremely fair and objective. There has to be no harassment, and there has to be tangible policies that are followed up on when the situation arises. And that's how employers tend to win these cases. As long as they follow up on accusations and follow the plan that they've set into place when there is a dispute about bias or discrimination, they're probably okay in court. But in those instances where the employee could prove that, oh, the discrimination was here and you did not follow the policies that you had, then the employees might be able to win those particular cases. All right, folks, that's all I wanted to talk about this time. I'll talk to you again soon.